Good morning, everyone, and thank you for coming back for the second day. I hope you had a good day yesterday and found it as thought-provoking and stimulating as I did, and I've no doubt that today will be the same. I'm Shehzad Charania. I'm the Director of Legal Affairs and International Relations at GCHQ, and also a member of the steering committee of the conference. And it is my absolute pleasure to welcome here Karim Khan, KC, Prosecutor of the International Criminal Court. Now, Karim genuinely needs no introduction, and so I'm not proposing to give him one. And that's because he is so well known as one of the world's leading international criminal lawyers. Now, you will know, of course, that Karim has represented both defense and victims and prosecution in his past life, and is now, of course, the prosecutor of the court. I think it's fair to say, and we might come to this later, that this is probably one of the most highly pressured, stressful jobs in international criminal law, possibly international law as well. So Karim, welcome. How are you this morning?
I'm very well, and very good to see everybody here. Thank you for being so punctual. I'm amazed, but thank you.
Thank you. So Karim, I'd like to structure this conversation in two parts. The first is to ask you about some of the situations you're dealing with, and we'll have a particular focus on Ukraine. But I'd also then, in the second half, like to talk to you about some of the institutional issues relating to the court, and in particular the office of the prosecutor. But I want to start first by recalling that in May last year, we had a conversation event like this, and a record of which is on the Opinio Juris website. And it was 3 weeks before you took on the role of ICC prosecutor. And I asked you at the end of that conversation how you would want your tenure to be remembered. And you said this, you said, I will want to assure myself that I have given the role my all, and that I have left behind an office which is more able and confident, part of an important institution and broader movement advocating for law over war. How's that going?
Well, I'm giving it my all, but we have a lot of work to do in many areas, and I think all one can hope for is that the whole office keep working together, that we try to improve our own performance, and also try to explain the important role of the law at this moment so that others can also improve. We need support from states, we need to build partnerships with international organizations, and I think we've achieved already quite a lot of breakthroughs, but we need to consolidate and we need to deepen that.
So one of the other things we talked about in that conversation was Afghanistan. And as I said earlier, this was 3 weeks before you took on the role. And very soon after you became prosecutor, you issued a statement saying that in light of the limited resources that you have as an office, and in light of the severity of the crimes in Afghanistan, you were going to focus your efforts, the office was going to focus its efforts, on crimes committed by the Taliban and ISKP. Now, that was not uncontroversial, because the former prosecutor had spoken about investigating allegations of crimes committed by the then Afghan government and the US. So can you tell us a little bit about your thinking behind that prioritization?
Well, it's a great question. Of course, one took quite a lot of stick for decisions, and that's par for the course. But the reality was this, that for 2 years prior to that, there had been no investigations at all, because the situation was deferred pursuant to an application, an admissibility challenge by the government of Ghani in Afghanistan. The events, I think it was in September, of the Taliban takeover of Kabul, and an escalation of what we were seeing in terms of gender persecution, crimes against girls, and and women, and also the rising tide of ISIS Khorasan required me, I thought, to make an application to the judges for permission to investigate on the basis that the issue of credentials didn't need to be addressed, whether it was the Ghani government or whether it's the Taliban. There simply wasn't active investigations. So we should move forward. That's all I said in the application to the judges. What I decided to do, and I did so knowingly that there'd be a bit of a slap that I would receive, is I issued a statement. Because I do think international law and the resources of the office are finite. But I didn't want to give the impression that I was doing something which I was not. And I'd much rather disappoint people by honesty than give the appearance I'm doing something which I don't, which is, if not deception, I don't think it's up to the standards required of this office. So I issued a statement and saying, based upon the gravity of the situation and the allegations we were seeing, that I would focus the meager resources of the office against the Taliban, crimes committed by the Taliban and the crimes committed by ISIS Khorasan, simply because they were the worst crimes. Now, the independent expert review, this was a report that States commissioned, it was released a few months before my election. It highlighted that the office needs to do better, and the court also, when it comes to prioritization. And they gave three options, really, of about, a priority situation, deprioritization, and hibernation. Hibernation basically is what was used by my predecessor when it comes to the Sudan situation for many years. For 4 or 5 years, the situation was hibernated. It means there was no real activity at all. I decided that because of the resources, and given I inherited 16 situations around the world, and also I opened, other situations like Venezuela, that I should simply state where we are focusing on and why. The allegations that we see in terms of internationals, for example, the allegations against the CIA in relation to black sites and torture, of course, are awful. And I've said I will collect that evidence, we'll try to create space and build partnerships for complementarity so that the mechanisms that are there, we can also try to encourage states to discharge their international law obligations and ensure that there's no impunity, or at least narrow the impunity gaps. But I think it's simply part of a communication strategy. And what I told some NGOs when they were livid with me, I said, you'll be crying blue murder if I say, okay, I can do everything in Afghanistan, but the price is doing nothing in Myanmar, doing nothing in Philippines. So I have resources that I've been given by states. How do you deal with it? Except by making tough decisions, but decisions hopefully that are based upon principle, not expediency.
So you talked there, I think the words you used were resources are finite, you talked about meager resources. But you've also talked about new situations that you've opened, and you mentioned Venezuela. The other one is Georgia. And Georgia is important, I think, for a few reasons. One is because it's the first time the court has indicted Russian nationals. As part of the South Ossetia de facto administration. But it's also the first time that the court has issued indictments for individuals outside Africa. And when we were at this conference in 2019, Africa was the focus of any discussion about the ICC, the allegations of an anti-African court. You know it very well because you were in the midst of that when you were defending William Ruto, the now president of Kenya. So, first of all, can you tell us a little bit about where you are on the Georgia situation? But also, can you tell us a bit about the extent to which it was in the forefront of your mind, or in your mind at all, that the importance of having indictments of individuals that weren't from Africa?
To be honest with me, it wasn't a factor whatsoever. In the advice, in the papers I had been given, of course, it was mentioned that it was important to proceed. The investigation had started for more than a decade. it took place in terms of the investigation. The events in South Ossetia took place in 2008. It was mentioned, of course, it's the first case outside Africa. I think those are completely irrelevant considerations. Although now it answers a criticism, I don't think it's a proper reason to proceed. One needs to look at the evidence, first and foremost, the jurisdiction, and moving forward. At the same time, it is the first situation that we've looked at outside the continent of Africa. But of course, the argument also is a bit nuanced because Africa also is a very rich continent. And there are differences in terms of, say, the Arab parts of Africa in the north. And the court had issued many years ago, the judges had issued arrest warrants in terms of, say, Libya, some of the Libyan suspects. So I think we conflate things in a way that's rather simplistic. But if you look now where the court is, you're right. We're looking at Myanmar, we're looking at Philippines, we're investigating in Venezuela, and of course we have an active investigation in Ukraine and Georgia. We've issued, the judges have issued warrants in relation to that.
So can we move on then to Ukraine? And we are seeing the horrors unfold before our eyes. You have been in the field a number of times now. I think you have an office in the field. You've spent a lot of time with government officials in Ukraine. I know that you have talked about your attempts to engage with the Russian side with no success. Can you just give us a sit rep on how the investigation is progressing?
Well, I've said that I will prioritize my resources in terms of Security Council referrals first and then state referrals, and we have 43 states that have referred the Ukraine situation to the court. I've been 3 times to Kharkiv and to Kiev and Bucha, Borodenka and other parts of Ukraine. Since May, we've had a continuous field presence. I think we've built, going back to the first question, really some very innovative partnerships. So, for example, for the first time in the history of the court, we joined a joint investigation team with now 6 countries under the umbrella with the assistance of Eurojust. We have partnered with now states, the Netherlands were the first, and then Belgium. We have another 11, I think, willing to join, which is a rotational model of short-term deployments of forensic experts, crime scene experts, that can deploy to the field and move forward. Since May, I've had a continuous field presence in terms of my office in Ukraine, and they're there now. And as I mentioned in an interview yesterday, like many children and women and men in not just Kiev, but in many cities and locations, they were down in the bunkers as the latest onslaught took place in terms of the missile attacks. So this is a complex, difficult area to investigate. A crime, an ongoing conflict is never easy, but we have to be there in order to have the best chance of separating the truth from fiction. And I think we're trying to focus our resources so that, I keep saying, the law cannot be a spectator. I've spoken repeatedly about the need in this moment of crisis for a new common front of legality to be seen by people, not just talked about in halls like this, but actually be seen by people who need the law the most. And I think it's a big challenge, but I think international criminal justice with the professionalism, and if we get partnerships, if we can review different data sets and use technology, I think the law is not as impotent as some may hope it is. And that's the test for all of us, to put the law and to show it has relevance.
So certainly in one or maybe 2 of the sessions at the conference yesterday, there was discussion about how many mechanisms there are, international mechanisms, seeking to bring some sort of justice in Ukraine. I think one of the panelists put it in this way. He said that people were falling over themselves to assist. Now the ICC is one actor, but as I say, there are many others, including the Ukrainian government itself. So perhaps if I start with the Ukrainian government, it has said, I think very recently, that it wants to prosecute 99% of the crimes itself. So in that context, what is the role of the ICC, where effectively you have a government seeking complementarity in action?
Yeah, no, it's a great question, and there's many parts to it. In terms of the last part, the main issue, complementarity is one of the bedrock principles, as of course everyone knows, of the Rome Statute. So we have jurisdiction only if the state is unwilling or unable to prosecute. But if you look at the legal architecture in Ukraine, there's no concept of command responsibility. They don't have the legal possibility to employ the doctrine of superior, military command or civilian superiors. So that's an area, obviously, where they don't have the legal tools that the Rome Statute gives us to investigate in terms of very often high-level perpetrators. So that's just one example. The simple reality is I'll be the first to applaud if Ukraine or any state takes on a greater responsibility to investigate crimes in their jurisdiction. That's what we want. It can't be carried by the ICC. The ICC needs to work to sometimes act as a catalyst for improvement, but also as a hub in which we can, give technical assistance. We can also share information, but we can also use our skills and put before our independent judges evidence that can be subjected to very robust scrutiny. And then that's how records are created that stand the test of time, because we have judges that are not parties to the conflict. We have prosecutors from all over the world, and that has a resilience that I think, definitely complements and enhances, the laws that may be applied in Ukraine. In terms of the first part of the question, there is a multiplicity of actors, and I think one has to understand why. Ukraine was facing an existential threat. I was just looking if Irina Vendikova, the former Prosecutor General of Ukraine, was in the room. She was here yesterday. But I think the Ukrainians have done really, under her leadership, and now the new Prosecutor General, they're making a lot of efforts to discharge their responsibilities. But we do see in many areas of the world this stampede, because politicians around the world want to be seen to be doing something. That something may be paradigm, it may be the most effective, it may sometimes be ill thought out or not completely refined. We're trying to bring a sense of coordination, because I convened along with the Foreign Minister of the Netherlands and the European Commission, a ministerial event a couple of months ago. We've established a dialogue forum with a number of states in which we're trying to respect the independence of various actors. We've got the OSCE, we've got Commission of Inquiry from the Office of the High Commissioner for Human Rights. But I don't think there's a trade-off necessarily between the independence of different mandate holders and coordination, so that in the end, the money that is given by states for enhancing international law and the protective purpose of international law when it comes to international criminal law can be rendered more effective. And that requires confidence of the different mandate holders and a willingness to engage, but also a sense of responsibility that as we are in The Hague or we're in London and we are discussing wonderfully interesting concepts of law, people are terrified about what is going to happen tomorrow, not just in Ukraine, but in so many other parts of the world. And I think we need to feel very acutely that sense of hope that people who have nothing at all have in the law. And I think we have talked a good talk in the international community for a long time. There has been significant landmark moments that one has to applaud, but we have not yet delivered the promise of international law. We may never do, but we can certainly do better than we're doing at the moment.
What's your view on the Special Tribunal for Aggression?
My view. So, we heard this wonderful talk yesterday for those that were at the dinner by Sir Christopher Greenwood, and I couldn't agree more that we should focus on the law that we've got instead of the law that we wish we have. I mean, there's that adage, you go into war with the army you've got, not the army you wish for. You go into these situations, it's been written about in terms of the law we have. The law we have in terms of the Rome Statute has been debated by many, many states. It deals with genocide, crimes against humanity, and war crimes. It was sufficient in the former Yugoslavia, and it led to indictments of Milosevic and Kradic and Mladic and John Kabanda. the danger of creating extraordinary mechanisms that give a jurisdiction and give definitions for situations that may serve a political purpose, but we're not willing to have those laws applied to ourselves, I think is extremely dangerous. And we should look closely, in my view, of the law of unintended consequences, not only because of the fragmentation of international law, but I think it could lead to probably a well-founded argument on selectivity, because the first aggression is not in Ukraine. There have been other instances where aggression's taken place, and I think we shouldn't give easy arguments to any individual. We need to stick with the law and actually, going forward, do a better job of applying the law, even if it comes at a short-term political price, or even if it seems to be in the short term, it represents a short-term inconvenience or even short-term setback to the national interests of a country. Because what we do see is, if we take an expedient view to the law instead of a more principled view, we get something that resembles the Wild West, in which what we have is not the protection of the law, we get the bully and the bullet. And I think we're seeing this in many parts of the world, and it's down for states to act with a degree of greater wisdom than maybe we've displayed over the last 10, 15 years, which is maybe manifested by a degree of complacency and expedience.
So I'm glad you raised...
But it's for states to decide.
Yep.
Yeah, obviously.
I'm glad you raised selectivity, because you have asked states to make voluntary contributions to the OTP, and many have come forward with both financial contributions and staff contributions. So how do you avoid a perception that this is impinging on your independence, or a perception that those states that give you money or staff will, in terms of staff, be predominantly from the global north, and in terms of funding too, but ultimately that they will benefit in some other way, whether that's in terms of situations or staffing, whatever. How do you avoid that perception that the states that give a financial contribution on voluntary terms are getting a benefit in some other way?
Yeah, no, I mean, there's that argument has been raised, and there are those that see a problem to every solution. But I just think the Rome Statute is clear. I mean, more than 20 years ago, the drafters included Article 116 that clearly envisaged the possibility and in fact an express provision for voluntary contributions. I have simply, and I said it before my election, we've gone around with a begging bowl for years, wringing our hands about lack of resources. We need to look at more imaginative ways to partner with the private sector, with states, and to make sure that we make international criminal justice more effective and less, academic and theoretical. So we're using a provision that's there in the statute. In terms of the argument that it compromised independence, I simply don't see it. I mean, nobody has said that nobody really credibly in the United Nations and some of the states, that the Myanmar mechanism or my former mandate, the UN team investigating ISIS and Daesh, or the IIIM, or the United Nations for that matter, don't have the imprimatur of independence simply because we know who the biggest funders are. And so we are funded. We don't manufacture money. We don't have our own mint in The Hague. We need money from somewhere, whether that comes from a general budget or that comes from a trust fund. What I've made very clear is the money is not earmarked for a particular situation. The money is used, and it is being used across situations. The secondments are also being used across situations, and particularly the priorities I've identified and I've spoken about quite publicly. Now, in terms of secondments, we've also tried to mitigate the reality that this particular moment represents an acute financial, fiscal crisis to many states. So, for example, one of the contributions we've received is, more than €1 million, and we've had another contribution supplementing it from another state, in fact, Cyprus. We're using it particularly to encourage secondments from countries that can't afford the cost of living in The Hague. So that some countries from GRULAC or from the Caribbean or Asia or Latin America particularly, and that are underrepresented in the court, we can encourage states to provide secondments, pay their salaries back home, but we can give an amount of money for their travel and for their living expenses in The Hague because of the exchange rate system. So this is a way of just trying genuinely to make the office improve in a way that is as egalitarian as it can be. And I don't see any of that compromising independence one jot.
Thank you. It's very clear. So can I move us on to some of the institutional issues that are on your plate? And in September 2020, the independent expert review issued, and there were, I think, 380 odd recommendations in there about how to improve the court. Some of them related to the kinds of things we've been talking about, such as investigations and the like. Others related to workplace culture. Most people, people who will have read this report will certainly recall that there were that some of the most striking elements of this were allegations of bullying, of sexual harassment. Can you tell us a little bit about how you've sought to deal with these recommendations and how you may have dealt with some of these already in your year in office?
Yes, an important one, because I think it really stunned many people to see the conclusions of the independent expert review. It talked about a climate of fear. It talked in terms of instances of sexual harassment and bullying, a perceived distance between the leadership and the office, and an atmosphere not of a lack of trust, but distrust that was there. And an office divided in that manner cannot, in my view, hope to succeed in the field or in the courtroom. I established a workplace panel of five, in fact, independent individuals. I consulted with the registrar of the court. We've got a very good registrar, Peter Lewis. Unfortunately, he'll be coming to the end of his term in March, and also the independent oversight mechanism. And they have spoken to, I think, more than half of the staff. Rather, half of the staff have decided to speak to them. They have issued a report to me. I have referred various cases to the independent oversight mechanism, whether it's required suspension pending investigations of some staff, whether it's also appraisal issues. That those mechanisms have taken place, and I will be circulating in the next, 10, 12 days, that report to the staff internally, and then I'll make it known to states and the public as well, moving forward. I've also appointed a special advisor on workplace culture, Perna Sen, and we're also putting forward a roadmap, and we're going to invite staff also to join another kind of committee, because the office, any organization has to be nimble. It's not the case that reform or improvement will finish. We need to deal with toxicity and an environment where people feel they're not equal and they are being discriminated against, or they don't feel safe. But at the same time, workplaces need to keep evolving, and that requires some basic architecture to be built in. But I think we've made already big differences with the assistance of states. Before we had a female, my predecessor, of course, was Fatou Bensouda from the Gambia. But below that, everybody was male, all the directors, all the deputy prosecutor, out of the senior lawyers, everybody except one person was, the senior trial lawyers, all of them were men except for one. We now have a deputy from Fiji, a wonderful woman, former ambassador, first female high court judge in Fiji, first female DPP in Fiji, former president of the Human Rights Council, Nazat Shamim. We have a wonderful deputy, Niang from Senegal, trying to also improve the balance in terms of the respect for the French language in the pillar, not because of political correctness, but really for efficiency. When we're dealing with Francophone situations, we have the skills, so we don't need interpretations. We've brought in now a director level who's a female, and we're trying to increase the diversity in the office. we've started open door policies and lunches. I meet every month with different teams to have lunch with them. The deputies are doing the same. So it's a work in progress. But the main thing is, some would say don't wash dirty laundry in public. But I just think in this day and age now, we have to sometimes expose what are the lived experience of some staff. It's not of all staff. Some staff have had wonderful working environments. There's wonderful staff in the office. But you can't ignore those that have been miserable. And it's done for leadership to make sure we look into that and we try to address what we can address in a fair and transparent manner.
So I've had a question come in. That's why I've been checking my phone, by the way. I'm not
But I was just rabbiting on too much.
No,
there we
are. And it links in to what you've been talking about. So I'd like to read it out and see what you have to say. And it was something that came up, in fact, in the International Criminal Law panel yesterday, too. So the question is that you've spoken about the need for gender equality in your office, particularly in senior positions. The independent expert review recommended term limits going forward for new hires. But this question says, what about all the senior men who will remain in their positions now, which means that there's still no room at the top for women? What can you do about that?
Yeah, well, I agree with those. And I've stated that that's the position, my clear position, that the ICC is too small to be a career organization. The Assembly of State Parties have said it's not a career organization. And also, if you look at the private sector, you look at the government, when it comes to technology, when it comes to even the practice of how we present evidence in courts, it's not static. It is really adapting all the time. And I think we need to have an office, particularly at this P5 level, which is the senior level and above, that we do have term limits. Judges have a term limit, I have a term limit, the deputies have a term limit, and I think at P5 level, we should have a term limit so that people come in, they play their part, we say thank you very much, we're extremely grateful for your work, they can leave and we can refresh, get new ideas, and also that gives you the flexibility of getting the right staff for the right situation, because you want language skills, you want, there is a difference. If you're investigating ISIS, Daesh in West Africa, the skill set may be a bit different than if you're dealing with a post-election violence case. So you want to try, to the extent you can, to have both institutional memory, but also, particularly at the senior leadership levels, have more flexibility. And I think it will also benefit those staff that are, say, at P4 level, because we don't have the career options. People can go into the UN if they can apply for the UN, and there's wonderful opportunities, or go back to the private sector or back to government. But those that don't manage to get promoted, they may say, well, I'm quite pleased about that because I don't have to leave after 5 years or 6 years or 7 years, whatever is the term limit. So I think we need to look at things in a way that may be uncomfortable for some, but I'm certainly on the side of those states and that believe we should have term limits. It'll make us more innovative and it'll keep us fresh.
Do you have any frustrations at the moment being in your office on any of the things we've talked about?
That I can say publicly on a Tuesday morning,
yeah.
Whatever it is. No, I think, look, there's always frustrations. I mean, institutions, I think whether it's government service domestically, we've got the legal counsel, Miguel Suarez speaking, whether it's the United Nations, I'm sure, or the ICC. Big institutions tend to be plagued with all the wonderful people we have and all the wonderful goals and ideals with inertia. And institutional inertia can be a default position, driven by many issues, sometimes a climate of fear, sometimes, sometimes it's too easy to go through the motions, and sometimes we create administrative frameworks that are not geared to the requirement of delivery. And this also linked back to the budget. If we don't deliver, if we're not seen to be having an impact in the real world, it's not surprising that every year for the budget, we go around with a begging bowl for really a few pennies. We talk about the aggression tribunal. I mean, my budget increase for 2023 was, I requested 13 million. The Committee on Budget and Finance have recommended 11 million. Now, honestly speaking, this now debate is going to go on until December. I am sure if you quantify the number of ambassadors and capitals and my office that are discussing 11 million, the cost that we're requesting is not going to be far off the amount of cumulative expenditure on this. And then people want to talk about an aggression tribunal when we can't even get the 11 million for the Office of the Prosecutor or the 20 million for the court. And I think this is something we need to think quite carefully about. When you look at the billions spent on weapons, it is simply an indication that the normative values of international justice are embraced by many. But in some capitals, there is a view that the impact is not sufficient to justify greater resources. So part is on us and part is on those states, but we need to try to change the dynamic so that we get the resources we need to have the impact that victims and survivors expect from us and that states actually have promised when they speak about situations we see around the world.
Great. So I think we might have time for a couple of questions, as long as people promise to ask questions rather than make statements. I mean that with all respect. While people think of questions, can I ask you a final one from my side, which is yesterday, and this might go beyond the law conference, but yesterday was World Mental Health Day. Now, you have one of the toughest jobs in international law, as I said at the beginning. A lot of hours, a lot of stress. You probably don't see your family as much as you would like. And you're faced with very high expectations from people in this room and the wider international community. What are your tips for retaining good mental health?
I think the tip would speak to a professional, that he's an expert on good mental health in all seriousness. There are so many experts now on wellness. There are experts now on workplace culture to take time. I think everyone's different. I think that's the first thing. Everyone is different. Everyone deals with things differently. I think things are much easier if you really enjoy what you're doing. If work in any line, I think, if it becomes too much of a chore, if you feel drained after long days as opposed to feeling tired, but also energized of a productive day, one should think about changing the area. And this is the wonderful thing of the law. There's so many areas. People shouldn't feel they are in a box and a space becomes effectively a prison rather than an opportunity. The other issue is focus is important. When you're dealing with an office and whether it's politics in the office or frustrations that in the office, I think if your focus is not on ourselves but on the victims and survivors, also it does make you raise your head and it lifts your spirits because you're not doing it for base reasons. We are trying to do something that matters. And really, genuinely, I was very moved. I was in Sudan I guess it was 6 weeks ago, and it was my first trip to Darfur. And I went to the camps, a Kalma camp, 30,000 people were there in this one camp I went to. And the camp was opened in 2004. And they were singing my name, welcome, welcome, Mr. Khan, welcome, welcome, ICC. And I actually felt a bit of a fraud. And I told it to the Security Council that I don't deserve that gratitude or that welcome, and the ICC doesn't, and you don't, as a Security Council. Because these people genuinely, and they're just reflective, the same in Cox's Bazar, delete as applicable. People really have this hope that international justice is meaningful for them. And I think those of us, whether it's the International Court of Justice or whether it's the European Court of Human Rights, we do need to look at their expectations and don't fret the petty. Try to find ways to make this body of law, our respective bodies of law, work much more effectively. And then in terms of others, we can use technology. In my last mandate, 3 years I was in Iraq, in Baghdad, and investigating ISIS. We pioneered some work with Microsoft and others using technology. So when you see these awful videos of people being burnt alive or children pulling triggers and killing toddlers who can't speak, killing people, and people drowning, you don't need to keep staff also, case managers, analysts, lawyers. It can give warning signals. So of course you look at it once, but not everybody needs to be exposed to that. So there's different ways of also reducing re-traumatization, and we've also issued booklets, trauma-informed field guide booklets, and we've just issued something now with Eurojust for civil society organizations. So there's a whole panoply of measures. I think really what is helpful is what you've done, is by raising the issue. I think that's where we've come along in leaps of bound, particularly since COVID, but maybe a few years before that, talking about mental health, because very often we see, a facade. I think that, the Mayor of London said something, it wasn't the Mayor of London, but talking about suicide. Colleagues may be going through things, whether it's financial or family or depression. And I think it's this awareness to realize that, in Islam, there's a saying of the Prophet, peace be upon him, that a smile is charity. It doesn't cost anything. Realize however terrible your day, and whatever you're going through, you don't know how somebody else has been coping. Just a smile and saying a few kind words can actually make somebody's day that is otherwise is lonely and feeling, that their voice is not heard. So that not just self-awareness, awareness of how we can be a positive impact on our colleagues or a negative one. I think all of that is probably things we should pay attention to.
Great, thank you. Karim, I think we only have time for one audience question, so I don't know if we actually have... Yeah, we do. Just
a bit of a long answer to the last one.
No, it's not at all. So quick question and quick answer, please.
Thanks. I'll be very brief then. You gave a list of states outside of Africa which you were currently investigating in relation to various crimes, of course. You didn't mention Israel-Palestine, and therefore my question is simply, why not? And what is happening in that respect, if anything?
Yes, we have an investigation. I mean, there's many others I didn't mention as well outside the region, but we have an investigation in terms of Israel-Palestine. I've engaged very closely with the Palestinians and the Palestinian Foreign Minister. In fact, just recently in New York in September, I met Riyad al-Maliki. I've been invited to Palestine. I've accepted, and I've also reached out to Israel for permission to enter Israel as well. These are complex situations, but I've also inherited an investigation without a team. We have a team going there, but I also have a variety of priorities, and we have victims in many parts of the world, including Palestine and Israel, that want to see can international criminal justice succeed, even if there are very many political questions around many of these situations as well. But we're doing our bit to the extent we can.
Thank you. Thank you, Karim, for being so generous in letting me ask you a whole range of questions and for giving such full answers. Thank you for being part of this conference. It was great to have you.
Thank you so much. Great honor.